The concept of nomination and the question as to whether a nominee is entitled to the property absolutely and whether the nominee becomes the owner of the property is a question that has perplexed and quizzed several people for quite a while. And today I seek to provide some clarity on this concept of nominee versus beneficiary or legal heir or legatee. To commence with all of this, we need to seek certain clarity on certain legal terms. We need to seek clarity on certain concepts of law. Let us first understand what a nominee is. A nominee, as defined by the Black's Law Dictionary, is a party who holds bare legal title for the benefit of others or who receives and distributes funds for the benefit of others. Now we need to pay attention to two very crucial aspects of this definition. One is bare legal title, which means it's just bare legal title. It is not absolute title. And secondly, and very importantly, it is for the benefit of others, which means the nominee does not hold property for his own benefit. Let us then see the concept of a beneficiary. A beneficiary is a person for whose benefit the property is held in trust. So very simply, the relationship between a nominee and a beneficiary is the nominee holds that property in trust for the benefit of the beneficiary, which means the beneficiary is the ultimate person to whom the property or the fund would vest. The next definition that I would like to look at is legal heir. Legal heir is a person who, under the laws of intestacy, is entitled to receive an intestate decedent's property. We then look at the definition of legatee. Legatee, as defined by the Black's Law Dictionary, is one who is named in a will to take personal property or one who has received a legacy or a bequest. Very simply put, a legatee is somebody who receives some benefit or a legacy under a will. Now, having understood the concepts of nominee, beneficiary, legatee and legal heir, let us distinguish between a nominee and the legal heirs. A nominee is a person who, by virtue of a nomination, is entitled to receive, as the definition said, bare legal title to the property or to the fund. The beneficiary, as the definition suggests in terms of being the absolute beneficiary or the absolute owner of the property, would include a person for whose benefit that property or fund is left behind. In simple terms, a nominee is merely a trustee or a caretaker to the estate or property of the deceased. The legal heir is a person who is entitled under the law of succession applicable to the deceased to inherit the property. Having understood this, it makes it very clear that the nominee is not an absolute owner but merely a caretaker, while the legal heir is the absolute beneficiary. The next question that comes into play is the role of a legatee in all of this. Now, a legatee comes into perspective only when the deceased has left behind a will. In cases where there are no wills, the property will devolve under the law of intestate succession, which means it will go to the legal heirs as per the law applicable to the deceased for the time being in force. However, when there is a will, the property will devolve as per the intentions or the testamentary intent contained in that will. Which means the legatees, the people or the persons who are entitled to benefit or hold benefits under bequests made in that will be entitled to that property. I am now going to take up a few frequently asked questions that have plagued each other's minds for years, if not decades. Questions like, does a will supersede a nomination or the legal heirs? Is a nomination necessary? Is a will necessary? What happens to my property when I expire? And these are questions that we will address in this video. Firstly, does a will supersede a nomination? Yes, a will does supersede a nomination. It will also supersede intestate succession, which means the property will devolve as per the testamentary intent contained in that will. Therefore, there will be legatees, and the legatees will receive the property as per the testator's intentions, as per the bequest contained in that will. The next question people ask me is a nomination necessary? While a nomination is not absolute in terms of its benefits to the nominee, the property would finally rest with the legatee or with the beneficiary or legal heir. But yes, a nomination is necessary. Even if you've made a will, a nomination ensures ease of transmission of that estate. So your property will transfer temporarily in terms of bare title to the nominee, and thereafter it will pass on to the legal heirs or the legatees. Another question that constantly keeps popping up is a nomination absolute? Is a nomination enough to secure my assets? And to answer that question, the answer is a blatant no. A nomination only means that the property or the monies will temporarily vest in the nominee. However, the legal heirs will be entitled to claim it from the nominee, or in case of a will, the legatees will have to claim it from the nominee, and it is the duty of the nominee to ensure that these properties which are kept for the ultimate beneficiary are actually transferred or passed on to the beneficiaries, as the case may be. Another very interesting question is, should I make a will? Is a will necessary? Whichever way you term it, if you have properties to dispose and you do not wish that people fight over your properties post your demise, yes, a will is necessary. Another very pertinent question that keeps arising all the time is, does the nominee get to keep the estate if there is no will? And the answer to it is absolutely not. Because when there is a nomination, the nominee only holds it as a trustee or a caretaker. The property will still have to be transferred, will eventually go to the legal heirs under the law of succession, which means ultimately it is either the legal heirs or the legatees who are the beneficiaries. And the nominee is merely a trustee or a caretaker to that property, a person who is entrusted with the responsibility to ensure a smooth transition of the property from the deceased to the ultimate beneficiary. Now, having answered most of these common questions that keep arising all the time, the fundamental point that we're making is you need to make a nomination for an effective and a smooth transfer. But it is the law of succession or the testamentary disposition that will take precedence. Therefore, you need to consider making a will, or your properties will devolve as per the law of intestate succession.